Good afternoon. This is Sean Golding with Golding and Golding. I hope everyone's having a great summer. We thought we would follow up our presentations with a common issue we see involving inheritance and gifts. And basically, it's what happens when you inherit money from a foreign country. So what happens when a person inherits money? And I'm assuming for purposes of this presentation that the person inheriting it is a U.S. person. So when you're dealing with inheritances and estates and things like that, there's two aspects to it involving the IRS. There's the tax implication, and then there's the reporting. General rule is the U.S. taxes a worldwide estate. So Jim in the United States, who has assets in the United States and abroad, or Jane, who is a U.S. person and lives overseas, she has assets in the United States and abroad. All of those assets, the worldwide assets, are totaled to determine whether or not they exceed the exclusion amount. So just because you live overseas doesn't mean that the U.S. government isn't going to include both your foreign and your U.S. assets. Now, in determining for estate tax purposes, you have issues involving tax treaties. I think there's about 16 gift and estate tax treaties, and they don't all cover both gift and estate, to keep it super complicated for you. And then there's domicile rules. The domicile rules for estate tax are different than the income tax rules, so that's something to keep in mind. But let's go through the basics here. U.S. person reporting an overseas inheritance. So U.S. person resides in the United States, or is just a U.S. person. Well, let's keep it simple. Let's assume they live in the U.S. and a foreign relative passes away. Now, if that person who lives overseas, considered foreign, let's say, but is actually a U.S. person, so that they lawful permanent resident, U.S. citizen, technically they may have met the substantial presence test and was just overseas, but assuming either of the two main categories, then what happens is it's an estate tax issue. And so from a reporting standpoint, the estate has to determine what the value of the estate is, the assets. They may have to file a form 706 regarding the estate value. But the key point I'm trying to get at is it's still on the estate because it's a U.S. person. The reporting of the people who receive the inheritance, not that big of a deal. The estate may have some tax implications. There may be future tax implications for income generated from assets received from the U.S. person who inherited it. But at the end of the day, it's still the estate. That's the key ingredient. This is different when the person is a non-resident who lives overseas, so that they are not a U.S. person, they're not a U.S. citizen, they're not a lawful permanent resident, they didn't meet the substantial presence test in the current year. And in that kind of situation, typically only the portion of the estate in the U.S. is taxed, but now the U.S. person who receives the inheritance has a whole host of things that they may have to do. Generally, when a person receives a foreign gift, they have to file a Form 3520. And for estate purposes, estate and gifts are different. For reporting purposes on Form 3520, an inheritance is a type of gift, so you would have to report that. There are many different forms a person may have to file. The main form regarding the inheritance itself is a Form 3520, but there's various other forms depending on what they inherit. If they inherited some foreign accounts, they may have to file the FBAR, Foreign Bank and Financial Account Form, FinCEN Form 114, a Form 8938 for FATCA, a Form 8621 for PFIX, which is primarily mutual funds and ETFs, other pooled funds. 5471, this is a common situation where a U.S. person may have received a gift of a foreign business, like a family business, a portion of it, depending what the value is. It's very common for taxpayers to not know anything about these sort of requirements because the IRS really doesn't publish that much information on it, other than hearing about the court cases where people were penalized, 5-6-figure penalties, even more. If a person is non-willful, then they have various programs they can submit to. There is the streamlined filing compliance procedures, domestic and foreign. Both of it refers to foreign assets, accounts, investments, and income. It's just domestic is for U.S. persons residing in the U.S. and foreign is for people who reside overseas. There are delinquency procedures and reasonable cause. If a person is willful, then they would only do the voluntary disclosure program. That's a much more complicated program, and it's very important you speak with a board certified specialist who specializes in these types of matters, or a few of them, to get a good idea, because some of these less experienced attorney scoundrels are all too quick to just throw you into VDP and, kind of give you some false sense of being able to get the penalty reduced and things like that. We have lots of free information available on our main website and our sub websites. You can always reach out and schedule a reduced fee initial consultation if you think it's appropriate, and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your summer.